think it is proper to allow people into the country before the entire screening process? Where are you with that? How many people are you letting go? I want her to understand the question I'm asking.
What you just heard inside the House of Commons raises a serious and uncomfortable question. Are criminals in Canada receiving lighter sentences simply to protect their immigration status? These aren't rumors or political spin. These are real cases raised on the parliamentary record where judges allegedly reduce sentences because deportation might follow. That leaves Canadians asking, is justice truly equal for everyone, or is the system quietly bending behind closed doors? Because if this is happening in courtrooms today, what else is happening that the public doesn't see? Stay with me, because what comes next affects victims, public safety, and trust in Canada's justice system.
Here with us today, I want to expand a little bit on this question of crime and how we treat criminals in this country. Should criminals receive more lenient sentences to protect their immigration status, in your opinion?
I don't believe they should, no.
Okay, well, my colleague referred to Jasbir Singh. That was a case very recent, just Calgary, 2024. And that is a case where the judge considers immigration status when assessing the case. That's one example. But let's go to another one. Ashwin V. Sajavan spied on a woman in a bathroom where he made video recordings. He received a more lenient sentence to stay in the country. In fact, in that case, the judge decided to give him less than 6 months instead of the mandatory 6 to 12 months, just so it would not affect his immigration status. Is it your position or the position of the Liberal government that we should give peepers and rapists a second chance to stay in Canada?
No, absolutely not. Again, as I said, sentencing decisions are not made by a government. They are made by courts. But no, there is a government will not, does not support such a thing.
Right.
When sentencing becomes controversial, the exchange you just watched highlights a growing concern in Canada, whether immigration status is influencing criminal sentencing decisions. The issue isn't whether judges are independent, but whether outcomes are creating a perception that justice is being applied differently depending on who the offender is. Engaging point mentioned below. 1. Judges are meant to sentence based on the crime, not future immigration outcomes. 2. Specific cases were cited where sentences were reportedly reduced. 3. Mandatory minimums were allegedly avoided. 4. Public confidence begins to erode when outcomes appear inconsistent. Why these cases trigger public outrage? For many Canadians, this debate hits a nerve because it touches on safety and fairness. Victims don't care about someone's immigration status. They care about accountability, consequences, and protection from repeat harm. Engaging points mentioned below. 1. Crimes impact victims the same way, regardless of who commits them. 2. Leniency raises fear of repeat offenses. 3. Communities expect the justice system to deter crime. 4. Perceived exceptions create anger and mistrust. Immigration status versus equal justice. At the heart of this issue is a difficult balance. Immigration consequences are serious, but they are not supposed to override criminal accountability. When those lines blur, Canadians begin questioning whether the system still treats everyone equally. Engaging points mentioned below. 1. Immigration penalties are administrative, not criminal. 2. Courts are not meant to compensate for immigration outcomes. 3. Equal justice requires equal consequences. 4. Any exception risks creating a double standard. Why Parliament is being forced to talk about this? This conversation didn't happen by accident. It reflects mounting public pressure, repeated court cases, and growing concern that the system is drifting away from common-sense justice. Engaging points mentioned below. 1. Similar cases are appearing more often. 2. Media and public scrutiny are increasing. 3. Opposition members are demanding answers on record. 4. Avoiding the issue only deepens public distrust. What viewers should pay attention to next? This is only the beginning of the issue. Once sentencing is questioned, attention inevitably turns to how these individuals entered the country in the first place, and whether safeguards failed long before the courtroom. Engaging points mentioned below. 1. Sentencing is only one layer of the problem. 2. Entry screening becomes the next focus. 3. Accountability shifts from courts to policy. 4. The next section reveals where the system may be breaking down.
But Minister, these are people that you let in the country, that immigration let in the country. They came, the Liberal government allowed them in the country. These are not Canadians. These are people that are here whose immigration status is being affected, whose judgment status is being affected in the courts, so that the judgment decision being affected in the courts, so that their immigration status is not affected. Okay, so it really does speak to the weakness we have seen in the background checks that are done before people are let into this country. So let me ask you this. Would you agree that we should prioritize justice for victims and safety for Canadians over immigration needs, over these criminals, peepers, rapists, and so forth?
So safety and priority of Canadians is always the priority.
Well, recently we've heard in this committee, as you very well know, from CBSA, there's 30,000 people they're looking for in the country they can't find. We heard from the president of the union of CBSA employees that they're demoralized. The staff is completely demoralized because they're not given the tools to do the proper background checks. In fact, your one-touch system, which is a first meeting with the person wanting to come into Canada, where they take a biometric of the eye and the fingerprint and so forth. Once they get that first initial meeting, they're given a questionnaire to take home that they have 45 days to complete before they give back. Do you think it is proper to allow people into the country before the entire screening process, ascertaining their criminality or their right to be in Canada, whether they should have a right to be in Canada because of the, if they have criminal records, they shouldn't be here and have the 45 days to complete the questionnaire?
So thanks for, again, I asked about this when I heard about this thingy called one-touch system. I was told that it's not really a one-touch system, but...
No, Minister.
Who is led into Canada and how? The debate now moves beyond the courtroom and into the immigration system itself. The concern being raised is not about legal immigration, but about whether the screening process is strong enough to identify risks before individuals are allowed to enter and remain in Canada. Engaging points mentioned below. 1. Entry decisions have long-term consequences. 2. Weak screening creates problems later in courts. 3. Once inside the country, removal becomes difficult. 4. Early mistakes multiply over time. Background checks under pressure. Testimony from CBSA officials has revealed a system under strain. Officers are facing overwhelming backlogs, limited tools, and increasing pressure to process cases faster, often at the cost of thorough vetting. Engaging points mentioned below. 1. Backlogs slow proper screening. 2. Staff shortages reduce investigative capacity. 3. Morale issues impact enforcement effectiveness. 4. Speed begins to replace caution. The one-touch system explained. A key issue raised is the so-called one-touch system, where the first interaction with an individual happens quickly, followed by delayed paperwork and extended timelines for full verification. Engaging points mentioned below. 1. Initial biometric checks happen rapidly. 2. Full documentation may be completed later. 3. Individuals can remain in Canada during this period. 4. Enforcement gaps appear before reviews are finished. Why the 45-day delay matters. Allowing individuals to complete key screening documents after entry introduces risk. During this window, authorities may not have a complete picture of criminal history or admissibility concerns. Engaging points mentioned below. 1. Criminal records may surface late. 2. tracking individuals becomes harder. 3. Removal processes are slow and complex. 4. Gaps increase public safety concerns. The 30,000-person question. The most alarming claim raised in committee was that tens of thousands of individuals are currently unaccounted for. Whether exact or not, the number highlights the scale of enforcement challenges facing Canada. Engaging points mentioned below. 1. Large caseloads overwhelm enforcement. 2. Tracking failures reduce credibility. 3. Public confidence weakens. 4. Accountability becomes unclear. Why this issue is escalating. When entry screening, enforcement, and sentencing issues intersect, the system begins to show cracks. That's why this debate is growing louder, and why Canadians are paying attention. Engaging points mentioned below. 1 point entry failures affect courts later. PARP. 2. Courts face pressure from immigration consequences. 3. Enforcement struggles amplify the problem. 4. The system appears reactive, not preventative.
I'm sorry, let me just say that.
Sorry.
Okay, that was clarified here by your officials. Okay, it's not an app. They have the one-touch system is something that is in place by your department. And what it is, it's the first connection with a person coming into the country. They have the one touch for them is the first really discussion they have with the individual. That takes a number of minutes, and they're allowed into the country with a questionnaire to complete the 45 days, okay? Now, here's the problem we have. We have people that are in the country that shouldn't be here because they're criminals. We have a backlog.
1 minute.
I'm sorry? 1 minute. We have backlogs that are really inundating all of our offices and members of parliament because we're dealing with real people here. The budget calls for a 15% cut in your department. Where are you with that? How many people are you letting go?
So let me go back to this one-touch system. The VP
How many
of
people-
Intelligence and
finish that question.
Enforcement
How many people are you
of the
letting go?
CBSA said that there's multiple layers of defense, and he clarified that somebody claiming asylum or at a port of entry, 100% of them
I just gave you examples. of
spent
people that are in
considerable
the
Menegakis,
country
time with
please let her
border
answer the
services.
question.
that should not be here.
Mr. Menegakis, please let her answer the question.
I am. I just gave you examples of people that should not be here, Minister. And they're here.
Mr. Menegakis, please let her answer the question.
So I
Minister.
think-
Could you please, Madam Chair, I'm communicating with the Minister. I want her to understand the question I'm asking.
Point of
I'm
order.
getting a
Point of
different
order.
Say she's not being able to respond. Mr. Menegakis, point of order, Ms. Zaid.
As chair, it is your responsibility to make sure to have a decorum. So I don't think so. This is a valid thing that he's questioning my honourable colleague is
on that
questioning
point
the
of order-
minister, and you cannot intervene. It is your job to keep decorum.
Thank you,
On
Ms.
that point of order, is
Mr.
that a
Meneg-
point of order for you?
This is not a point of order.
Okay.
Mr. Menegakis, we're going to your time is up in any
No,
case.
I'm just going to say to you, that's why we introduced Bill C2 and C12,
Minister-
because the
Mr.
system
Diab,
needs
it's
to be
over.
improved.
This-
We
the-
need to have
Minister
better.
Diab.
We need to have better tools, and that's exactly what we are doing.
Minister
So
Diab,
we're hoping that you will work with us to do that.
Minister Diab, just time is up, and
When answers start to fall apart. As the exchange continues, frustration becomes visible. Questions are asked repeatedly, examples are provided, yet direct answers remain limited. This moment exposes the gap between official assurances and real-world outcomes. Engaging points mentioned below. 1. Specific cases are raised but not addressed. 2. Officials rely on general explanations. 3. Accountability becomes harder to pin down. 4. Public frustration grows in real time. Multiple layers of defense. What does that mean? The minister points to layered security and screening systems, but critics argue that layers don't matter if they fail to catch serious issues early enough. Engaging points mentioned below. 1. Layers only work if fully resourced. 2. Gaps at any level weaken the system. 3. Real cases suggest failures occurred. 4. Reassurance without proof rings hollow. When procedure overrides urgency, as procedural interruptions take over, the substance of the issue risks being lost. Time limits, points of order, and decorum rules end the discussion before clarity is achieved. Engaging points mentioned below. 1. Important questions go unanswered. 2. Process blocks accountability. 3. Canadians are left without clarity. 4. Tension replaces resolution. Bills C2 and C12, solution or signal? The government references Bills C2 and C12 as evidence that improvements are underway. But for many observers, legislation alone does not guarantee effective enforcement. Engaging points mentioned below. 1. Laws require resources to function. 2. Enforcement matters more than intent. 3. Past fixes did not prevent current issues. 4. Skepticism remains high. What Canadians are still waiting for? As time runs out, one thing becomes clear. Canadians are still waiting for direct answers about accountability, enforcement, and safety. Engaging points mentioned below. 1. Who is responsible when screening fails? 2. How are risks identified before entry? 3. What happens when enforcement can't keep up? 4. These questions lead directly to the final takeaway. What you've seen in this House of Commons exchange isn't about party lines. It's about whether justice in Canada is applied equally and whether public safety is truly being prioritized. From sentencing decisions that appear to consider immigration consequences to serious questions about background checks, enforcement gaps, and accountability. This debate exposed concerns that many Canadians have quietly shared for years. If you believe these issues deserve transparency and real answers, make sure to like this video and subscribe to the channel. We follow these developments closely so you stay informed about what's happening in Parliament and what it means for Canadians moving forward.